It's a pleasure to introduce Mr. Mangesh Mokashi, our speaker for today. Mr. Mangesh Mokashi is well known to our ICT fraternity. He has been visiting faculty here at ICT for IPR for the past years now, and he is the Assistant Controller of Patents and Designs at the Mumbai Indian Intellectual Property Office here at Antop Hill. Mr. Mokashi has been deputed for today's program, which is being organized by the Ministry of Education, MIC, the Ministry of Education Innovation Council, as well as AICTE. With this very brief introduction, I request Mr. Mokashi to kindly enlighten us about today's topic, which is IPR awareness. Thank you.
Thank you, Dr. Shamla. Actually, this program has been conducted under the joint venture of Ministry of Education and Department of our department, that is Patent Department. Okay. And you might be knowing that recently we have some news in newspaper. Okay, the news was like that we have surpassed the national patent filing, means the Indian patent filing to that the international level. So it means that this year actually the near about 40,000 patent applications were filed by the foreign companies and foreign national, whereas our own Indian filing was about 60,000 in number for the patent. So I think that for last 1 year, we are working for the intellectual property, that is a IP awareness program. Okay. Before that, many other agencies like FICCI, CII, these organizations were working in the field of intellectual property awareness. But because of the NIPAM, National Intellectual Property Awareness Mission, it has been through our patent office, and then because of that, I think we have crossed the Indian patent filing. Okay, so I will just start. I will share the slide. These have been specifically made for the NIPAM, and these are the tailor-made. Okay, so just a minute. Can I share the screen? Yeah. Can you see? Hello. So
yes, it's visible. It's visible.
Oh, okay. So NIPAM under actually what happened? We are covering topics like the patents, designs, trademark, geographical indications, and copyright, semiconductor, and integrated circuits layout. So we know all these are cover under intellectual property rights. So suppose we take one product, one vendable product as such, we can see there are a number of IP incurred in that product, like LED display, it might be patented. Okay, so body or shape of the laptop, it might be covered under the Design Act, it might be protected under Design Act. Another, that Apple sign might be it is protected under trademark. User manual and software also, these are covered under the Copyright Act, and the layout of integrated circuits are covered under SICL Design Act, Integrated Circuit Design Act. Okay, so these are multiple intellectual properties are protected under single product. So now what happened actually, now suppose we have idea. Okay, we have idea. The idea in your mind cannot be protected. It must be utilized in the way that we have resource also. Okay, by utilizing resources, we have to work on that idea also. So if experimentation is carried out, then only we can have the property created, means intellectual property created. So here, these are all wheels, interrelated wheels. Suppose we are protecting our intellectual property. At the same time, what will happen? we will exclude others, from utilizing your protected intellectual property. At the same time, what will happen? If you will utilize that intellectual property and commercialize it, we can earn the lot of fame and the money also. These are all interrelated wheels. Okay. So utilization and commercialization can happen in number of ways actually. What happen? You can utilize that protected intellectual property for your own use. Then either another way is that you can license your technology or assign your technology to another person. Okay, either you can merchandise. Okay, merchandise means you can have the multiple people to and in the single product you can commercialize by putting your product in multiple different shops. Okay, either you can have your own franchisee under your name, and you can franchise that product to multiple people. That these four ways can earn for you. Okay, so for a common person, what happen? Suppose you are protecting intellectual property. What we can have as a common person, as you can have the pride. Okay, for academic purpose, you can. It can be considered, patent publication can be considered one of the prestigious point, even though the research publication in research journal bears some good value. Okay, so at the same time, if we think in the mind of the businessman, what will he do? He will earn and invest more. He will earn in the for intellectual property protection and invest, and because of that, what will happen? The brand value will be created. Because of these two, why it is happening? This is happening because of commercialization of intellectual property. So now we will go through the patents. What is patent actually? So patent is granted by sovereign state to the person. To the person means includes even government or a private company also. Okay, so an invention for limited period. Patent is granted for a limited period. Because of that, what should one do? He should disclose his invention to the patent office in form of patent specification. Right to exclude others from utilizing your invention is important, because here the monopoly will be created by protection of your intellectual property. Monopoly will be created. It will be for limited period. Owner has a qualified right to use the invention. We know that we can commercialize our invention by multiple ways. Okay, by licensing, by franchisee, and merchandising, or transfer of technology also. So here are some of the patents. Here is one of the main actually first patent granted in 1856 to Alfred D. Penning in India. Okay, it was for an efficient pankha pulling machine. Similarly, we can identify other scientists also, or inventors also, according to like the Thomas Alva Edison phonograph and Alexander Graham Bell telephone, aeroplane, rabies vaccine, penicillium to the Alexander Fleming. Okay, now we can see actually you might see only the feature of that product. Okay, so considered here as a nano car. For the nano car, multiples near about 200 patents were filed. Okay, so it is not even though the 200 patents were filed, it cost just about $250 US for the startup, providing the opportunity to middle class and middle income family also. Okay, similarly, we have the hepatitis vaccine from Santa Biotech. Okay, Santavac, it costs it is for the hepatitis vaccine. Okay, it costs only 40 cents a dose. 40 cents a dose. Because of that, why it is so low? Because multiple patents were filed for that product also. Similarly, Jaipur food, it is also protected under Design Act, and it costs just mere 28 US dollar to us. So these are some of the examples, but though these are only the picture, there might be multiple intellectual properties like a patent, design, and the copyright also under behind these products. So what is the procedure for the patent application filing? Now what happened, we know all, because the intellectual property and patent filing is one of the subject in the ICT. But even though I want to mention that the form 1, we need a form 1 as a patent application form. So and it needs fees to be paid. Okay, then form 2, details of invention, and there what will be there, title of application will be there, background of the invention will be there, particulars of drawings, brief description of drawings, brief description of invention will be there, and claims, abstract drawings, this will be there. Fees is not required to be paid if your specification is within the 30 pages and within the 10 claims. Okay, form 3 you need to file. What is form 3? Details of foreign filing or similar invention. What does it mean? Same application, if it is filed in foreign countries, you need to provide the information in form 3 also. Form 5 is a declaration of inventor. Suppose the application is filed in the name of institute. Okay, in that case, the institute has to provide a declaration that these are my inventors and their names are as such. Okay, so 1, 2, 3 inventors. So actual name of the inventor has to be provided and declared. It should be declared by the institute in the form 5. And another form 18 is required. What is form 18? Form 18 is a request for examination. Okay, it is like that. So suppose one student has taken admission for the course, but he has at the same time at the end of the course he has to apply for examination also. Okay, he has to file the examination form also. Similarly here also, the even though you have filed the patent application, you need to request for examination in form 18. So what are the fees for e-filing in India in Indian rupees? So for suppose natural person is there, or a startup company is there, or a small entity is there, or any educational institute. Earlier it was only limited to government institute. Nowadays any educational institute is considered as a natural person for filing purpose, for fee purpose. So in form 1, for form 1 only 1600 fees has to be paid, whereas for the natural person, whereas other than natural person or the big companies, they have to pay the fees of 8,000 rupees. Similarly, the form 2 is there. There is no fees like earlier I said, up to 30 pages and 10 claim. No fees for form 3 and form 5 also. Only for request for examination, there is a fees of 4,000 rupees. Whereas in case of the for the big companies, you need to pay 20,000 rupees as a examination fees. So overall, actually cost of patent filing is only 5,600 here. Okay, whereas here in case of the larger company, it is 28,000 rupees. Okay, so you can refer the schedule for the under the patent rule 2003. More details can be there. Then another filing procedure will be you can apply online. So submission of hard copy in appropriate patent office you can do. Okay, and actually you can file online also. Okay, suppose now there can be this things like that. Someone want to file your one's patent application in hard copy, even though there will be some more fees has to be paid by the applicant, but you can apply for your patent application online through this website. Okay, so here is the some photo of the snap of the actual online filing procedure. where you have to create your login ID and password also. Okay, you need to have the digital signature. I want to say here you need to have the digital signature. Okay, so now what happened? Now government has made a provisions that suppose someone want to have the early patent granted for his filed application. So in that case, you can go for expedited examination. Expedited examination can be filed only by the startup company, okay, or a small entity, or the applicant when the one of the applicant is a female, okay, or jointly with the other natural person. Okay, this provision has been made because of we want to encourage innovation, women entrepreneurship also. Okay, so another entity is like Department of the government or other government establishment also can go for expedited examination. Okay, so suppose any company has filed PCT application in India, then also they can go for expedited examination. Another criteria is that suppose there is any Japanese companies and we have provisions for PPH, patent prosecution highway. It is known as patent prosecution highway. If any Japanese company, we have signed the PPH only with the Japanese patent office. Okay, so in that case, any Japanese company want to file a patent application in India and they want to have expedited examination, then also we can provide that facility to that foreign company. Okay, so what is a patent application? Now, patent filing procedure in the patent office, what happened? There is a PCT application. Okay, there is a convention application and there is an ordinary application. PCT application means for the any patent application coming through the PCT route. Okay, convention application is any foreign application which has been filed directly from the foreign country to India within the 12 months. Okay, ordinary application means any application filed directly to Indian Patent Office. So these are three types of patent application in India. So what happens? Suppose we have filed provisional patent application, then we have to go for the complete specification within 12 months. Okay, and thereafter what happened? Your application will be published under section 11A after expiration of 18 months from date of priority. And thereafter what will happen? The examination of application by the patent office will be carried out, and the report will be submitted or the comments will be provided to the applicant, and for that comment the applicant for the patent has to be provide the reply comments. Okay, the comments in the reply. Okay, thereafter what happened? There will be examination of amended case also. Even though you have replied to the first comment, there will be another comment, means second examination report may be there. If even though you have not gone for the compilation or proper comment to your objection, then what happened? There will be a hearing before controller. So and after the hearing before controller, that patent may be granted or refused. So what happened? If someone filed the patent application to patent office, what happens? If your patent application is filed, then what happened? Inside the patent office, screening and classification of that application is done. Screening is done for whether your application is related to atomic energy or it is related to defense purpose. Then it has been that screening has been done. IPC classification means classification of application means IPC classification is assigned to that specific application also. Okay, there can be a multiple IPC classification for a single patent application. So based on this screening, if your invention is related to atomic energy, then that application is sent to Atomic Energy Department for consent, whether the Department of Atomic Energy has any objection for the examination or grant of that patent. Okay, so if that patent, that patent application, there is no objection from the Atomic Energy Department, then that application will be published. Okay, and go for examination. Then only it can go for examination. Similarly, in case of defense, if your invention is related to defense, then that application will be forwarded to DRDO, Defense Department. Okay, only after the proper approval from the DRDO, Defense Department, that application will be published, and then only it will send for the examination to the examiner. So what happened? What is examination there? So examination, there are two types of examination: formal examination and technical examination. Formal examination means what? Whether fees has been paid or not, whether the title is proper or not, and then whether your application has been signed digitally or not, and whether the name of the inventors are there in proper format or not. These have been checked under the formal examination, and thereafter what happens, there will be a technical examination also. Technical examination means for novelty. It is like a literature survey for your patent application, means invention. Okay, first examination report will be there. Okay, after both examination, there will be a first examination report. Okay, what happened what is there inside the first examination report? There will be a formal requirement, objection for the formal requirement, and objection for the technical requirement also. Okay, technical requirement and gist of objections are communicated to the applicant. So examination on reply of the applicant, even though the first examination report has been issued to you and you have replied to that first examination, then again the check of reply will be done, re-examination will be carried out for formal requirement also and technical requirement also. Okay, if you have not complied that requirement, what will happen? Then the technical discussion for pending objection between the applicant and hearing officer will be done. Who is the hearing officer here? Is a patent officer. Okay, so based on the hearing, then grant or refusal of your application will be decided. So technical examination, I am again coming to the technical examination, read and understanding the invention. That is the main, we have to read your application, okay, in the patent office, then understand that invention also, along with the drawings, along with their any sequence listing is there, along with any examples if there you have provided. We have to decide, we have to analyze your invention. Okay, based on that, we have to find out the keywords also. Okay, so search for the related publication will be made in the worldwide databases. Like these databases may be the paid database and freely available databases. Okay, so what will be there in the examination after the search? We need to find out whether your patented pending application or pending invention is a novel or an inventive. Okay, with respect to citation. So we need to make a comparison between the cited document and your invention. Okay, so and based on that, a technical report has to be prepared. Technical report has to be prepared. It is known as technical examination in the patent office. So what are the basic timelines for the patent application? Like for provisional application, if you are filing provisional patent application, and then you want to file the complete specification, then it will be 12 months. You have to file within 12 months a complete specification. You can make a request for examination within 48 months from the date of priority. Okay, date of priority means initial filing, first filing. And then reply to IPR has to be made within 6 months. Form 3 has to be filed within 6 months from date of your priority. Okay, Form 5 has to be paid within 1 month from your date of priority. Okay, withdrawal of application in Form 15 can be made before grant of application. Okay, before publication of your application, you can also request for withdrawal of application, and before grant of any application or grant or refusal also, you can withdraw your application. Okay. So what happened? Then thereafter, the hearing submission must be made within 15 days if your application is in the hearing stage. Okay, before the controller, and you have been heard before controller, means technical discussion between patent officer and in between applicant or inventor has been already happened. Then the hearing submission has to be made. Any suggestion is there, any modification is there, that has to be provided within 15 days. Okay, so we know that we can oppose any patent application. Okay, there are two types of opposition. That is one is pre-grant opposition, and second one is post-grant opposition. So for the patent attenuation, any aggrieved person, okay, any aggrieved person can oppose your patent application to your patent application before the grant. That is known as pre-grant opposition. Okay, once patent is granted, and if any aggrieved party want to oppose that application, that is known as post-grant opposition. And post-grant opposition can be filed within 1 year from the date of grant. Okay, so now we are in the design section. Okay, you know, and we all know design. A lot of design application has been filed by ICT under the Design Act 2000. Okay, and Design Rule 2001. These are the design. What does it mean? Design means only the feature of shape, configuration, pattern, or ornament, or composition of line or colors applied to any article, whether 2-dimensional, 3-dimensional, or both forms, by any industrial process or by or means, whether the manual, mechanical, chemical, separate or combined, which is in the finished article, appeals to and are judged solely by art. Means what happened? It does. It means that it's only related. Design is only related to the outer structure. Okay, outer structure of any article. So, but does not include constructional features, substances, mere mechanical device. Okay, so this will not be considered. So, term of design is for the 10 years and extendable by 15 years. So, this is a definition of the article. Article means any article of manufacture or any substance, artificial or partially artificial or partly natural, and includes any part of article capable of being made or sold separately. These are the legal definitions. What is original means? Original is there. Original means what happens? Suppose someone has made the Taj Mahal shape bottle. Okay, Taj Mahal is already there, and he has made the bottle in shape of a Taj Mahal. Then also the design protection can be granted to it. Okay, so design. What are the examples of the design of an article? That is sofa set, even the mask also, even the outer structure of the bicycle, outer structure of the any lamp, or the reactor also, even outer structure of the reactor also can get a design protection. Okay, so set of articles. Okay, so design can be granted to the set of articles also. Set means a number of articles of a same general character, ordinary sold together. Okay, ordinary sold together or intended to be used together. That is a definition of for the set of article. Another examples are the set of jewelry, set of tea, sofa set. Okay, these are the examples of a set of articles. So what happened? Similarly, like a patent application, design application can also be filed online electronically. Okay, but if someone want to file application physically, so he has to approach patent office. So respective patent office in your jurisdiction. Okay, what happened after filing application? If you are going to file your application physically, then that application will be digitized Okay, it will be electronically processed for examination, registration, publication, and post registration. Okay. So what are the requirements for ordinary design application? So application only the 1,000 rupees. Okay. So the application form 1 will be there. What will be the content of form 1? Again, the applicant's full name, nationality, legal status. Okay. Then address and addresses of services in India, class number. Okay, class number, it is related to the design classification. Okay, so priority data, suppose if there is any already used or any application already filed outside of India, then can you have to mention the priority data, prior registration data also, and signature and date will be there. So two sets of representation illustrating the various views of article, power of shall be there. Okay, and then power of attorney must be there. Assignment document, if any, then you have to provide assignment. If you are only the representative, then that has to be provided. Then form 25, if it is applicable to only two small entity and startup. Okay, to discount, to claim the discount in the filing fees. So that documentary evidence has to be provided for the small entity and startup. Affidavit for foreign companies, only the affidavit can work. Okay, to consider the small entity. So this is a publication specimen. Sorry, this is actually specimen how you should provide the photo of your design. Okay, to the design registration. Okay, this is the certificate of design registration. Okay, though it is provided by the patent office, but it is not a patent certificate. Okay, last time what happened in ICT also, some of the faculty members have provided the design certificate, design registration of design as a certificate to administrative office, but what happened, patent is different and design is different. Okay, patent is mostly 99.9% is related to technology, innovation, invention, whereas the design may be artistic only. Okay, so this cannot compare, design registration cannot be compared with the patent grant. Okay, patent certificate. So after grant of your design, your application or the granted application will be published. Okay, so this will be the format, design number will be there, class will be there, and the name of the applicant will be there. Okay, and date of registration will be there, title will be there. It is a chest compression device for the first step. Okay, priority data will be there if any. So showing your IP is protected. How actually you can mention that whether it has been registered or not before delivery or on the sale of any article to which registration or design is applied, registered or RD, and also a registration number can also be mentioned there. Okay, this may deter the potential infringer and help in legal action. Okay, so you can mention whether your design is already protected or application is pending for design registration. You can mention on the packing or even on the product also. Okay, so important timelines for ordinary application, that is 10 years. It can be extendable another by 5 years, means total 15 years. Request for renewal has to be filed with the, within 10 years. Okay, to extend for another 5 years. Request for restoration of lapsed design to be, even you have failed to renew your design application, you can renew your application within 1 year from date of cessation. Okay, so now we have come to the trademark topic. Trademark is already very known actually topic. it is related to everybody. So concept is that a trademark is any word, name, symbol, or device, or combination of thereof. It identifies and distinguishes the sources of goods or the service of on one trader from another. Okay, what is the function of the trademark? Provides the exclusive monopoly over the class of goods and services. Okay, allows the business to entity to build a public goodwill. Goodwill is their brand reputation you can build up along with that. Okay, so thereafter it identifies the source and origin of goods from origin of goods and services. He can identify the applicant also, means which is the company. Okay, and then assures the customer about the quality of goods and services also. Okay, these are the some of examples of the trademarks. These trademarks may be the service marks. Okay, trade names also, collective marks may be there, certification marks may be there. Okay, taglines and slogans may be there. Okay, shapes and sound marks may be there. So certification marks is there, the BIS, Bureau of Indian Standards. Okay, so these are all the trademark examples of trademarks. So what is a good trademark actually? It should be a very inherent. It can be acquired also. It should not deceptively similar. Okay, it should not be deceptively similar. It should be honestly adopted or coin word. These are more preferred. Coin words are more preferred. Not similar to already existing mark. Before adopting new mark, it is advised that one should carry out the search for the trademark before using any trademark. Okay, before using or utilizing your trademark on any product, he should carry out the search for the product or in that class, whether it has been already in use or not. It will avoid the future litigations also. So for the registered trademark, unregistered trademark and application, if the registration for trademark is pending, you can use TM also, and you can use the R. You can use the R only when your trademark is registered. Okay. So another point is that how to protect your trademark. Trademark registration is optional. It is not necessary as such, but it is necessary when you want to go for litigation. If you want to contest for the infringement. If someone is copying your trademark, then you have to register your trademark. Okay, registration will be available at national and regional and international level also. Initially, trademark is registered for 10 years and further can be extended for 10 years for indefinite times. Okay, like a Tata is one of the trademark for near about more than 100 years. Okay, so for each 10 years they have renewed their trademark. So in case of non-use and non-renewal or non-policing, trademark rights can be lost. Okay, so what happened? The existing trademark registration is governed by the Trademarks Act 1999 and Trademarks Rule 2017. So more information you can have from the our website. So this is also one of the important, like we used to send our research paper for the publication in research journal. Okay, so they already take our sign that all the copyrights will be assigned to the research journal. So what is copyright? It is actually, copyright is a bundle of rights. We know that a bundle of rights means all the rights like ownership, entitlement, transfer will be there. So similar kind of rights will be with the copyright also. It is an automatic right. Okay, when you have created, when you are using any trademark, okay, trademark or copyright. So from that day, your right will be yours. So it is an automatic right. Your right will be created. So it is an automatic right. It is an exclusive right given for creators or original original work of authorship. So more original creator. So it allows the owner to choose the way and his or her copyrighted work are made publicly available. You can choose how to make your product available, means copyrighted work available to public. Okay, so it can prevent the unauthorized copying and production also. Section 2Y of the Copyright Act defines the work, which type of work is there. Okay, so one is there, copyright cannot protect an idea. Okay, idea is there, something in your mind, but unless until you make it in the tangible form, means either in the form of book or the CD or on the website, that cannot be protected. Okay, so it should, to have the copyright, it should have a creativity, at least some minimum creativity in the work. It should be original, and it should form, fixation means what? Means it should be formed into the tangible form, like the book or the CD or the copyrighted material, other forms of the publication. Okay, so these are the criteria. Features of the Copyright Act, actually some of the provisions, if someone is interested in this field, copyright field, they can go through chapter 2, 10, 2 and 10, chapter 8. These are related to provisions related to Copyright Office. Okay, provisions for statutory and compulsory licensing, how to license your copyrighted material. These have been mentioned under the chapter 6, 4 and 10. Okay, so provisions related to right to ownership of copyright and tenure protection, these have been mentioned under chapter 4. So now there are some of the provisions related to broadcasting also. Okay, and performance also, these have been mentioned under chapter 8. And the infringement, if your copyrighted material has been infringed, okay, someone is copying, then the remedies and infringement procedures have been mentioned in the chapter 11. So there are different sections under the Copyright Act. There are definitions also for literary work. It is under section 2O, and the artistic work or dramatic work, that is section 2H. For artistic work like a painting, it is under section 2C. Similarly, for this the sound recording, it is under section 220. Okay. So what are the definition actually? What are the definition under section 2D actually? Who are the authors? Like for the literary or dramatic work, it is known as the author. Creator is known as author. Music work, it is known as the music composer. For the artistic work, other than the photograph, it is called as the artist. A photographer will be known as person who takes the taking the photograph. Okay, and the cinematograph film, that is the sound recording also, the creator will be ownership will lie with the producer. Literary, dramatic, musical or artistic work which is computer generated, then the person or the who causes the work to be created is the first owner for that copyright. Okay, so there are two types of rights under the copyright. So first right is economic right, and second one is a moral right. Economic rights are transferable. You can suppose one person has created the copyrighted material, it can transfer to the another person. Okay, but moral rights are not transferable. So what are the economic rights actually? What is the scope of the economic rights? So production right for the reproduction, okay, right for the distribution, right for the creation of derivative work, right for communication to public, okay, right for public performance. These are all rights will within the economic rights. So there another scope of the moral rights. What is moral rights? Right against distortion. Okay, so here we can see that the right to object to the work being distorted or used in context that are prejudicial to the honor and reputation of the author. This can also be only with the moral right. Author can oppose distortion. Original author can oppose the distortion of the original work in such a way that cultural or artistic integrity it is adversely affected. Okay, so right of recognition also. Suppose someone is copying your copyrighted material or copyrighted material, then also the original creator will have the right to claim to be author of the original work also, and copyrighted material also. Okay, right to have the author's name mentioned on, for instance, when the work is reproduced. So this right will be also there. Okay, we can see the example of the Shamche. It is a Marathi book. Okay, so rights with Vidyarthi Gruh Prakashan for that book, Shamche Ai. And it was now seized actually after 60 years of death of the original creator. So term for protection, it has been mentioned under section 22. Okay, so published literary and dramatic, artistic, musical work. So for scenario up to it will be 60 years from the date of publication. Okay, broadcasting production right will be 25 years from the following years, and performance right will be up to 50 years from the year of following year for which performance has been made. So application procedure, there are similarly like in case of the patent application, trademark application, here also in copyright you have to file the form. Okay, so form 14 will be there. Each such a application shall be filed in the copyright office by person or by post also, or by e-filing also. You can file your application just by sending some person or by post also, and e-filing facility is also available with the copyright office. So examination of application, there will be a prescribed fees. For literary or artistic musical work, you have to pay the 500 rupees. Okay, so for artistic work, and to be used, capable of being used on goods and services also. If it is on the specific product, then you have to pay the 2,000 rupees. And in sound recording, you have to pay 2,000 rupees. Cinematograph films, you have to pay 5,000 rupees. So what is the procedure for the having a copyright in your name? You have to actually rights are created as such when you have made any copyrighted material. Okay, but if you want to apply for the copyright, then application has to be made. Then what happen in examination, formally check when you file your application to patent copyright office, formality check will be there, there will be waiting period, scrutiny will be there, and scrutiny will be for discrepancy if there is no response from the applicant, even though letter has been sent, then application will be abandoned. If you are going to reply to your discrepancy and discrepancy is removed, it would be going to the deputy registrar of the copyright, and even though there is an objection, then there will be a hearing, and then there will be no registration of your application. Okay, if there is a hearing, if there is a yes, all the requirements have been made, then there will be a proper registration of your copyrighted material. So this is a Semiconductor Integrated Circuit Layout Design Act. So under this act also you can have the protection. Okay, so similar Semiconductor Integrated Circuits Acts, it means the product having transistor and other circuitry elements inseparably formed or inside the semiconductor or insulating material designed to perform electric circuitry function. Okay, so like if we have laptop, and similar functions can happen in the your mobile also. Okay, so that is called as but for that purpose, the creator has to modify all these things. He has to redesign the integrated circuits. Okay, so that can be protected under SICLID Act. So there will be a layout design, means layout of the transistor, and the other circuitry elements include the lead wire, connecting, and such elements expressed in the manner of SIC. So all these will be formed as a SICLD. Is important IPR for protection of products with fast changing technologies such as electronic gadgets and computers. So registration, you can have protection up to 10 years. Okay. So what is the procedure actually? Once you have filed the application, the objection will be communicated to you. If there is no reply from you, then your application will be refused. Okay, registrar may accept with some modification and hearing. Okay, if hearing is there, and that will be accepted. Accepted application will be advertised within 14 days of acceptance. Okay, any opposition there? Here also the opposition can be filed in the Layout Integrated Circuit Act. Okay, if there is a opposition, if opposition accepted, then it will be refused again. Okay, if there is no opposition, or if opposition is refused, then your registration will be granted. So these are the fee structure for the application of integrated circuits application. So now I think I can skip that video. Okay. So now we are covering the geographical indication. Geographical indication is an indication that identifies goods that have specific geographical indication and possess qualities or reputation that are due to that origin. Origin means geographical location. Okay. So Darjeeling tea is there. Okay. Makwana marble, Bomli Veena, and Bastar Dhokla is there, and Venkatagiri saris will be there. All these are human created GIs for the product. Okay, human created products and GIs granted for that. Only thing is that Nagpur Santra, okay, that is related to naturally occurring product. So naturally occurring product, that is Darjeeling tree, that is Makwana marble, Ratlami Sev, Kanchipuram silk. These all have the GI. Geographical GI means geographical indications. So similarly, Katputli of Rajasthan, Bagh prints of Madhya Pradesh, Bengal, Patachitra, that also they are there. Okay, Cherial paintings, beadware, and Warli paintings. Warli paintings is mostly related to Konkan region. So naturally occurring products will be there. Magi Pan, Devanstali Pomelo, and Apple Midi mango will be there. Kashmiri saffron, Shahi Lychee of Bihar, Kurk orange. All these have the GI. So IP is everywhere. Again, I will skip. So validity, what are the validities for the patents now? We want to concise. Okay, so validity of for the patent is 20 years. The term of the patent is 20 years. There is nothing called global or international patent. Suppose many applicants show that if their publication has been published in WIPO, okay, so that PCT publication, they will show that I have world publication, okay, world patent, but nothing in reality, nothing is like that. The patent is granted only by the government of specific country. Okay, so there is nothing like global or international patent. So design will be granted for 10 years. It will be extended. It can be extended by more 5 years. Okay, trademark can be granted for indefinite time, but it will be granted initially for 10 years. Okay, GI indefinitely subject to renewal. GI can be granted for 10 years and it can be renewed for indefinite times. copyright depends on the type of the copyrighted material. So who can apply, person or individual for GI? Okay, so person or a legal representative. Persons includes firm, partnership, small entity and body incorporate can apply for patents, design, trademark and copyright. But what happens in case of GI? GI application can only be made by association of producers or association of manufacturers. I will give one example. I think 9 to 10 years before, there was an application by the Reliance Petroleum, okay, Reliance Industry for the Jamnagar petrol, okay, Jamnagar petrol. But what happened? That application was made by Reliance only. There were no association of producers or manufacturers of petrol. There was a single entity. That's why that application was refused on that basis, because the GI application can only be granted to the association of manufacturers or association of producers. So now point to remember, first to protect and then publish. We all know that still many faculties are used to publish their research paper first and then will go for the patent application. But we can make a reverse, like we can go for patent application because fees is very less nowadays, even for university, even for educational institute. Okay, but for the other bigger companies, even for startup also, they can go for first to file. Okay, because of that, what happened? Even though you have filed patent application, there you can publish in later stage. You can publish you can demonstrate your product also. So right is territorial, means what happened? The US patent application will not be have any implication in India unless until that same patent application is filed in India. Similarly, suppose any patent application filed in India, but it is not protected in US or Europe, so there will be then anyone can copy that application, your patented invention in US or in Europe. Okay, but these whether you want to file the patent application in US or Europe, that these are all business decisions. Okay. So registration is done by sovereign authority, means here in the case of Government of India, and specifically if we think that patent is on in India, authority is a patent office. Okay, so right for limited period. This is very important point. Okay, you cannot have monopoly for unlimited time. Okay, so monopoly is granted only for limited time. So right for limited period of the time only. Okay, so no automatic relief. So what happens? Suppose someone is copying your invention. Suppose someone is copying your copyrighted material. Suppose someone is copying your design, registered design. Then what happens? You cannot get automatic relief. Okay, so for that purpose, you have to make a complaint against him. Okay, and you have to go in court of law. Okay, so renewal fees has to be paid for every IPR protection. Okay, so appointment of patent agent is not compulsory. Many institutes say that, even the universities say that, is it compulsory to appoint a patent agent? As per the Patent Act, it is not necessary to appoint a patent agent. Okay, if I know that there are in ICT, there are a lot of faculties, they file their patent application on their own. So it is good actually. Okay, so except for copyright and trade secrets. So what are the career opportunities in the patents? Actually, here you can in the government you can work in the field of examination, that is examiner of patents and design, examiner of trademarks and GI, examiner of copyright. I will again say that you can also be one of the faculty member in a lot of colleges. They are hiring the intellectual property specialist, specifically like for innovation innovation, faculty for innovation, or something like that. In other fields, like you can work as a patent agent also, trademark agent also, JRF, SRF also. You can work in patent litigations department in private sector. In many big companies, there will be an IP manager post nowadays. Specifically, there will be a big team like 30 people will be there. I have seen that some of the small companies also nowadays they are also hiring the people specialized in the IP field. Even though these are the small entities, so there can be 20 people in small companies also for IP protection. So you can contact like we have the RG&I PM intellectual property management for actual courses conducted by this institute. Okay. Okay, thank you. Do you have any question?
A small request to all participants to kindly fill the form given in the chat box for attendance. There is a Google link that is pasted. Please fill that Google link. That's for your attendance. You'll get a certificate from the organizing committee. Thank you. Yes, any questions from anybody?
I have a question.
Yeah, ma'am.
So in one of your slides, you said something like for foreign filing, there is no patent fee required. I think it was your slide number 14, where you said that for foreign filing of similar invention, no fees are required. So I just wanted a clarification on that.
40, is it 40?
14.
Okay, just a minute. Yeah. So this slide is actually related to Indian patent filing. Okay, so there is no fees required for Form 3 filing the Form 3 details.
Okay, got it.
And
all right.
There is and there is also no fees for Form 5. That is a declaration of inventorship. So that is there.
Okay, got it. Thank you.
I have another question.
Yeah, sir.
Okay, sir, can I directly go for the foreign filing without filing at the Indian Patent Office?
Yeah, definitely you can go for directly foreign filing, but for that purpose you need to take a permission from Patent Office. Okay, so in that case, what happened? You can have 1 or 2 pages of disclosure of invention to the Patent Office. Okay, and then based on that permission, you can directly go for foreign filing.
Thank you so much, sir.
Okay. Any other?
So if there are no questions, I will take this opportunity to thank our today's speaker. On a very short notice, he agreed to deliver this talk. Yesterday, I met him for the first time. So much, sir, on behalf of Vice Chancellor, Team IIC, Dean RI, and everyone attending the lecture. So we all are very thankful to you for gracing the occasion and delivering this excellent talk. And in case of further questions, we will definitely get back to you. Of course, you are part of ICT once, so you are. We consider you our very own person or family member. So thank you so much, sir, for everything.
Thank you, sir. Thank you.
Thank you.
Thank you so much.
Thank you. Thank you, ma'am.
Yeah.
Thank you.